Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Pilta and Michigas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Thanks so much for coming to hang out with me today, this Thursday, May 21st, 2026. We are on day 3. This is only day 3. I thought it was day 4. Day 3 of the Commonwealth of Virginia versus Dr. Ebony Parker case. The first case in history in which a school administrator is being tried criminally for the aftermath of a school shooting. In this case, it was a 6-year-old first grader who brought a gun to school and shot his teacher, Abby Zwerner, who sustained terrible injuries, horrific injuries. She was shot. She had her hand, I guess, on her chest. The bullet went through her hand into her chest, 5 surgeries. I'm not sure what her lifelong injuries are. And, but I do know that she did sue the school district and Dr. Parker. And last November, in November 2025, she obtained a $10 million verdict against Dr. Parker, which has been appealed. I also know that the mother of the 6-year-old boy spent, I think, a little over 2 years in prison. She received a 24-month or 2-year federal sentence for lying on her firearm application by lying and saying that she did not use marijuana at the time she was applying for a license. I think she tested positive for marijuana after, or a couple times after. She served her federal sentence at the same time as the state sentence. The state sentence was for, I think, child neglect. And even though the sentencing guidelines were 0 to 6 months, the judge in the state case sentenced her to 21 months. We watched some news clips on that yesterday, which she served concurrently with the 2-year federal sentence. So she, the mother of the child, has done her time. She was just released about a week ago. And I think that the nuanced issue here is, do we start charging school administrators for school shootings? Essentially, I mean, she's on trial for 8 charges of child endangerment / child abuse / child neglect, not on behalf of the act or the shooting of the teacher, but on behalf of the children in the classroom who witnessed it, none of whom, thank God, were shot by this 6-year-old. And do we think that this is something that is now going to become a trend? Do we think that this is something that is a slippery slope, or do you think that these criminal charges are warranted? Because this woman, Dr. Ebony Parker, is facing up to 40 years in prison. And the criminal allegations are not that she did something, but that she failed to do something. That she failed to do something when it was brought to her attention that this 6-year-old may have a weapon. Remember, the reading teacher, Miss Kovac, did search the child's backpack when he was out at recess. She took it upon herself, even though she's not really supposed to. She said that the assistant principal gave her the permission to search the backpack, and she did. But what they have brought out during the trial, and in my opinion, it's not a whole lot. There's not a whole lot of evidence here to warrant or justify a 40-year prison term for this assistant principal. Is that one or two of the teachers may have told her that the child may have a gun. It seems, nobody was very alarmed. There didn't seem to be any sense of urgency or emergency among any of the teachers that we heard testify, even though the teachers do have the authority to separate the child from the classroom or to separate the classroom from the child. It doesn't seem like anybody really had any sense of emergency or any sense of urgency or any sense that this was really real. And if you were a teacher in this situation, would you pick up your phone and call 911 and get the police involved? I mean, can teachers be fired for that? I don't know. They really didn't get into that, even though yesterday they talked a little bit about the policies and procedures and the crisis management protocol. Civil case, yeah, it was a slam dunk, in my opinion. She got a $10 million verdict. Criminal? I don't know. I don't know where we draw the line. I don't know where we stop with this. If you're a teacher, if you're a school administrator, do you think that this woman deserves 40 years in prison? Because it's still not really clear to me. I mean, I guess when they showed portions of her interview that she gave in the post-shooting investigation, that she did say that somebody brought it to attention that the child might have a weapon, that he told another child that he might, and they wanted permission to search the child's body, and they're not allowed to do that. And she said, the mother's coming soon. Let's just wait. I'm really torn about this one, and I wonder where you guys are. And the Commonwealth has rested. Their entire case is in. So if anybody can point me to any slam dunk evidence that this woman deserves a criminal conviction in this case, because of her failure to act and her failure to search this student, please point me in the direction of it, because I don't know that the Commonwealth has proved its case. I don't know that the defense will even put on a case. What do you think? So I think the first thing we're going to hear this morning when we come into court, or when the court begins, is a motion for a directed verdict on behalf of the defense, alleging that the Commonwealth did not prove its case beyond a reasonable doubt, and that there's no way a jury can find her guilty of these 8 felony counts of child neglect. The other thing that I wonder, they did parade a lot of parents and put a couple of parents, let me see, 2, 4, 5, maybe 6 parents on the stand, but 4 of them were parents of the same, or 2 and 2 were parents of the same child. So really, parents on behalf of maybe 4 or 5 children took the stand to say that their child has nightmares, bedwetting, some therapy, and did sustain some emotional injuries because of what happened in the school. But I don't know that they've proven 8 counts, because in order to prove 8 counts, in my mind, they would have needed to have brought in at least parents of 8 children, and they didn't do that. And so just don't know. So the Commonwealth has rested. We'll see if the defense is going to put on a case today. And I don't know. Yeah, no one's going to want to be a teacher, let alone in administration, says Nicole. A lot of Nicole's here. Jordan says, I think possibly the 8 felony counts is too much. I was going to say maybe just 1 count for the teacher who was actually shot, but the charges are about the kids, not the teacher who was shot, right? The teacher can't sue the school district. The school district was let out of the civil suit because she's entitled to workers' comp. And in many states, if you're entitled to workers' comp, you're not allowed to sue your employer. Some teachers' contracts do not have that clause under their collective bargaining agreement. But in Virginia, apparently they do. The teachers are entitled to workers' comp for on-the-job injuries, and so therefore the school district was let out of that case. Now, all the parents who testified are all represented by the same civil attorney, and they all have cases pending against the school district for what happened that day. And so if this is going to be the seminal case, first case ever in our United States of America of a school administrator being charged after a school shooting, is this the case to do it with? I don't think so. I don't think so. Amanda says, good morning, Melanie. This case is baffling. Seems like they just want a verdict and put people on blast. I don't know. LV says, wasn't it mentioned yesterday that there were others who all were also aware the child may have a weapon? Well, there was one teacher, the counselor, who said that he thought that he did, but then he didn't feel like the child was. I almost feel like some of them didn't really believe that it was true. And so they kind of just blew it off. Even the teachers who were the first line of defense, really, because they're the ones who were told by, I think in one case, Ms. Kovacs said she was told by two little girls. And then I think it was the school counselor, I think his name was Mr. Rawls, may have been told by a male student, although he referred to him by initials. So we're not really sure if it was a boy or a girl. And I don't know. I hate sitting on a fence, but I just don't know how I feel about this right now. Becky, Crumbley's parents were convicted, but Oxford School failed on many levels themselves and were not held accountable for their failures. Correct. In Crumbley's case, we went over this and the Colt Gray case yesterday. Crumbley was, I think, 15 when he killed 4 of his fellow students and injured, I think, 7 others. His parents or his father had given him the gun for Christmas or a pre-Christmas gift. Both parents were charged in Michigan. That was the first time ever that parents had been held liable for a child's action or a minor's action in a school shooting. They are both serving 10 to 15 years on manslaughter charges. And then we have the Colt Gray was 14 when he took, again, another Christmas present, AR-15 style rifle to school in Georgia. His father has been tried for that on 27 counts. Colin Gray, and he has not yet been sentenced. His sentencing is going to take place in July. That child, Colt, has not stood trial. And I don't know. Maybe we just need to get metal detectors in all of these schools. Erin says the kid had an extensive history of violence and Dr. Parker knew it clearly from the kindergarten teacher's testimony. Also, I don't blame the teachers for not acting themselves. Well, I can only speak for myself. Okay. And if I'm a teacher and I think a child in my classroom has a gun in his pocket, I don't give a shit what the school policy is. I'm calling 911. She had, you're right. I don't know about it, but I can't say he had an extensive history of violence. The kindergarten teacher testified that a year prior to this, she was sitting in a chair and he came around the back of her. And at 5 years old, he had his arms around her throat. And she said that she couldn't move and she couldn't breathe. Is that an extensive history of violence? The other thing that the child did was 2 days before this incident where he brought the gun to school, he smashed Miss Zwerner, his teacher's cell phone on the ground and broke it. He was suspended the next day. And then the next day after that, he came to school with the gun. And so in a school of 500 children, and this is an elementary school, remember, perhaps, I don't know, because I'm not a teacher there or familiar with the student body, perhaps there were other children who were a lot worse than he was. I don't know. But in a school of 500 children, I have to think that he wasn't the only one who posed a threat to these teachers. Because when we read some of the interviews that were done after, so a grand jury was convened to investigate the district and its policies. And because of what the grand jury report that was issued, they did enact a number of changes in school district policy and in the district. And so some change has taken place. But in that report, and some of the teachers or administrators that were quoted in an article that we read, they said that teachers in that school were being assaulted by students on the daily. Like, this is not, he wasn't the only one. He was in kindergarten. Were there older children who were more of a threat? I just don't know. I just don't know. I find it hard to believe that he was the only child, and I just don't see this extensive history of violence. I know that he had some emotional problems, and he was on, a modified schedule, and during the day they were doing everything they could to accommodate him with the one-on-one counseling and the one-on-one teachers and the, so I just don't know. And then Aaron says again, his mother was required to attend school with him for a while, right? And she was scheduled to come in that day. I'm not justifying anything that the assistant principal did. I just don't know that it rises to the level of a 40-year prison sentence. We have people in jail for child grape who don't go to who aren't sentenced to that kind of time. And so I just don't know. I just don't know. But if it was me and I was a teacher, screw the policy. If my life is in danger and the children in my class are in danger, if the principal ignores me, the assistant principal ignores me, I'm going to take it a step further. There was no school resource officer in the school that day because they shared a school resource officer with another school. And so I just don't know, not 40 years, but some kind of accountability. Well, she's got a $10 million verdict against her. Once we start charging school administrators and putting them in jail for things that happen in the building, who's going to want to be a teacher? Is she being made a scapegoat? That's my other question, says to Jen. Jen says, it absolutely doesn't. She's being made a scapegoat here. This is a civil matter. I mean, how much are school districts and teachers and administrators required to do or face criminal charges? I don't know. Kelly says, I think she should be held responsible. It was her duty to act and she did nothing. But does she have a legal duty to act? See, that's the difference here. Okay. I can totally see it in civil court. Was she negligent? Yeah. Was she grossly negligent? Maybe. But does she have a legal duty to act in a circumstance in which even the school's own internal report said was completely unforeseeable? Unforeseeable. She was the only one who knew with authority to search him and told them no. But I don't agree with 40 years. Says Kelly Buston Justin. Thanks on top for your super sticker. I appreciate you so much. School hasn't started yet. School hasn't started yet. I mean, court hasn't started yet. Anon says, I followed the civil trial and I agree with the verdict. In this federal trial, this is not federal. This is state court. In this trial, I don't see where the state proved beyond a reasonable doubt. Plus, plenty of appeal issues if found guilty. Right. But if found guilty, she could be held in custody until an appeal winds through the court system, and that could take years. I mean, think about this. I think a lot of people who watch trials all the time, criminal trials, are very desensitized to the punishment here. Even 5 years in prison for this woman, to me, is too much. We watched part of her interview, and I think that the interview that they showed to the jury that was done 3 days after in the post-shooting investigation by the Human Resources Department of the district really humanized her. Maybe it'll help her if she testifies and shows some remorse, and is able to show some genuine tears. I don't know. But sending anyone to prison, it feels to me like a Law and Order episode where they can't get the perp that they really want to get. So they craft some very creative theory to pursue charges against someone else. And I think that if you're going to charge one person then perhaps you need to charge every other person who knew that this child might have a weapon and failed to act. But it seems to me like nobody really thought it was true. Even Ms. Kovacs said she thought it might have been a toy. So, I mean, I just don't know. Just playing devil's advocate with you. Thank you very much for your 10, Anon. And Anon says, I meant to say criminal trial. Okay, thanks. Mighty Midge says, I'm thinking that the child originally had the gun in the backpack and then put it in his coat. I agree with you. Remember, he said no one is looking in that backpack. So maybe if they checked it then, this wouldn't have happened. I mean, listen, it's real easy to Monday morning quarterback. Hindsight is always 2020. You know, John Tortorella, the coach, the hockey coach of the Vegas Golden Knights, formerly the coach of the New York Rangers, probably wishes that he would have talked to the press after the last series that he won in hockey, because he was fined $100,000 for not talking to the press and not doing the handshake after they won the series. And he lost his appeal. He probably says, I should have done it. But it's because the mother has already served her jail time in this case. Is it a bridge too far to now throw an assistant principal in prison? Thank you very much for your 20. When I was out there looking for another feed with better audio, I did find a station called 13 News Now. I don't know if they don't put up their live feed until the very end, but it seemed to me that their audio was better. So we'll see what we can do here. But I've got more people waiting for me than Law and Crime has for them. There's 318 waiting. We have over 1,400 in here. So smash that like button. Helps the algorithm. And it's good for the channel. So if you like what you're watching, hit the like button. If you don't, hit the like button on your way out. Either way, a view is a view, right? Ann says, it sounds like a lot of school policies need to change. I would have also just called 911 no matter what. Oh, thank you. Aurelia Smith, who apparently is a teacher, maybe. I've had administration wave off my fears of a potentially dangerous student. I fear a student coming up next year and have been told, oh, he's okay, just high strung. Teachers don't have the recourse you'd think. I guess calling 911 would potentially get you fired. Is that what you're saying? I don't know what state you're in. But I will say this to you, is that aside from police unions, the teachers have the strongest unions in the country. It's true. You don't ever want to cross the teachers union. They really are supposed to go to bat for their teachers. And so if you work in an inner city school district or a dangerous school district, my heart goes out to you, because teachers have a really hard job. Oh, please. Oh, you work at a private school. You teach at a private school. I see. Everyone's afraid of being sued, says DLD123. Well, they did get sued and they are being sued also. Now, listen, that's another issue. Do you think that these parents who came in and testified, it came out and the jury knows that there's a big civil case against the district on behalf of the students? And so they do have a vested financial interest in finding Dr. Parker guilty, because that makes their civil case stronger if there's a conviction. Bethany says he should have been removed from the school way before this happened. Okay. Students have rights too, right? Especially students that are on IEPs and other special programs. I would submit to you that there might be other children in the school who did far worse things than this 6-year-old and have not been removed from the school. But you guys can tell me. I know there's a lot of teachers in here and a lot of school administrators. But I think that many of us are just desensitized to the actual ramifications of what this woman did. And a lot of people are like, oh, just throw her in jail. Just throw her in jail. I just don't know. It's not like she did something. It's that there's a failure to do something. Very different in my mind. Phoebe says it was the Parker's responsibility to search the child, but she waited for the mother to come. Again, hindsight is 2020. If he didn't, let's say he didn't have a weapon and she did search him, I don't know. I don't know. I just don't know. Robin says she's a scapegoat because they can't charge the child. Someone has to pay, right? They can't charge the child, or they're not charging the child because he's 6. And they said the child doesn't understand the legal system, so we can't charge him. And I think custody was given to the great-grandfather, the mom's grandfather. The mom was 26 when she went into the clink. Mama says, Mama Rico, honestly, the school district is at fault because it's nearly impossible to have a child removed from public school. Thank you for saying that. Teachers and administrators have become babysitters to severe behaviors, right? And I don't know what kind of district Newport News Public Schools is. If anybody lives there and tell me. I mean, is it a dangerous district? Are there a lot of kids who are acting out in elementary school? I don't know. Stina G says, I think she's a scapegoat and don't like them going after people other than who did the act. The kid needs to be in a long-term facility. Amber Bauer says a school administrator is not a school teacher. Okay, elaborate. I mean, she says she had school testing that day. I mean, state testing that day, and she couldn't leave her office. But also, I submit to you, how many fires is a hypothetical fires or proverbial fires is a school administrator, like an assistant principal, dealing with on a daily basis? Because when I heard those teachers testify, none of them seemed to be genuinely thinking that there was genuinely a threat. And I'm not saying that's an excuse for anybody, but it's a consideration for me. Jenna said, yeah, I've had people wave me off and I took it into my hands and called 911. Are you a teacher? Scott, 25 years on the job, NYPD says, so if I'm taking an accident report, I should stay there if there's a robbery around the corner? I don't know. What do you think? Do you think she should go to prison for this? You know what it's like in a prison. Any corrections officers in here? I'm sure we have it. I'm sure we have it. Corrections officers in here too. Team Brittany says they're also terrified of losing their funding. Right. Emily said most likely she was having to do the testing for the kids with IEPs who have to have the questions and answers read to them. Tony says administrators aren't protected by the unions. That's why it's becoming more common to go after them. I did not know that. Is that on a state-by-state basis? Maximum Bacon says it seems that the state hasn't clearly explained how criminal negligence applies here. I'm open to the idea, but haven't heard it yet. Manic Mandy says, as a former special needs counselor in Canada, the biggest mistake our government made was closing special schools for special ability kids. It's important to amalgamate, but they need appropriate skills. Yeah, they're big on integration here in the U.S. They want these children to have as normal a school experience as possible. And it seems like they were doing everything possible for this child with his special modified schedule. Look at this. I told you we have all kinds in the chat. And look at DF says, not a corrections officer, but a prison psychologist. Feels the same some days. That's an interesting job. Wow. I'd like to know more from you. Emily Jane says, this is all because of No Child Left Behind. AMG says, in Massachusetts, the administration is a contractual agreement. Does that mean that they are protected by your union? Team Brittany says, bottom line, if someone didn't want to interrupt testing to deal with a weapon issue, it's stupidity at the highest level. Well, I agree there, but is stupidity a reason to throw someone in prison? I think is my question. I agree that there was a lot of stupidity going on here. But again, hindsight's always 2020. How many threats do they get in a day of things that aren't real? I just don't know. All right, here's court. It's empty. Look at we rarely have gotten a view of the courtroom in this Newport News, Virginia courtroom, and it is empty and it's big. But if this 13 News Now puts up a feed, their audio seemed to be better. Maybe they are the pool camera and everyone else is feeding off of that, which is why it's not so good. Oh, please. Oh, let's do our empowerment card of the day and our quote of the day while we are here and waiting for court to start. Every day we pull an empowerment card from the deck because who doesn't need a little empowerment for the day? A little something to get you going. We're running low on our deck. I'm going to have to get a new deck. Be you, do you, for you. Whoever needed to hear that today, you're welcome. Be you, do you, for you. I like it. I'm still holding this one from the other day, which I like a lot. Bad vibes don't go with my outfit. Another one from the other day. Thank you. Granny on the plane says working with disruptive kids is exhausting, and not just for the staff. The kids who need to be able to concentrate without distractions are the most vulnerable and abused, and all in the name of equity. Let me, yes, I agree with you 100%. I have 5 kids. Some of them went to public school. Some of them went to Catholic school. And every child is different in your family, and not every child is going to benefit from the same type of education. And I will say to you that it seemed more prevalent in Catholic school that the disruptive students were really disrupting the kids who really wanted to learn to the level of not in a good way. It was not a good educational experience. I can honestly say that as I sit here today for at least one of my kids. Okay, here we go. Today, Thursday, May 21st, 2026. Colin Wilson said, the mind has exactly the same power as the hands, not merely to grasp the world, but to change it. The mind has exactly the same power as the hands, not merely to grasp the world, but to change it. Colin Wilson. Focus, focus. Get out there and change the world, my friends. Do it. Just do it. Here's the defendant. We've only seen the back of her head. The way this pool camera is positioned, we have not seen the defendant's face at all during this trial. This is day 3. I don't think we've seen any of the faces of any of the attorneys while they're arguing either. And the audio has been a challenge to say the least. It has been terrible. And even when I went back on the replay, even though I've been trying to modulate each person as they're speaking, which is a very difficult task. When I went back and heard the replay on my phone, it sounds fine. On my laptop, not great. So I apologize if it's not me. It's them. It's them. Let's see what they're doing. Do they? The judge is not on the bench yet. Yesterday, there was a giant sinkhole at LaGuardia Airport, which caused the cancellation of something like at least 200 flights and massive delays. A couple of days before that, there was a giant sinkhole on the Long Island Expressway in which a car fell into. I don't know, is this like the season of the sinkhole? I don't know what's going on, my fellow Long Islanders, but you know how bad our pothole situation is already. We now need to add sinkholes into the mix. Sounds like their audio is up. We can expect motions first thing this morning. Motions to dismiss or a directed verdict is very unlikely, as always, after the close of the Commonwealth's case, but we'll see what happens in this case. Thank you very much for your PSA. I just need a latte, but we can't give medical advice on this channel. I'm going to delete it. Please only put things in the chat that you know for sure. As a fact, we don't do gossip, rumor, innuendo, speculation. Please don't give legal advice in the chat if you're not an actual lawyer. And please don't use the, just be careful with your language because the AI programs on YouTube are getting stricter and stricter. They don't like firearm talk in the chat, and they don't like certain words being used. The camera placement is totally bizarre. It's all the way in the back of the room. Usually they have them, to the side a little bit in a corner, like right over here by this door, say, or somewhere else in the room where they can get faces of the attorneys. Like in the Karen Reed, like if we're looking at the judge's bench like we are right now, in the Karen Reed trial, they had the camera over to on the right side, like in a corner over here to the right as you're looking at the bench. And that was a teeny tiny courtroom. Division Bell says, maybe it's me, but it seems like there's a lot less cameras used since Law and Crime took over Court TV, one at the rear of most of the recent trials and really bad audio. Yeah, and that's the thing too. And I've been saying this for a long, screaming from my chair to anyone who will listen, only you guys. Law and Crime and Court TV are now the same company. Okay, they're the same company. Why don't they choose different trials for each network? Wouldn't that make more sense than broadcasting the same trial on Law and Crime and Court TV? Here comes the judge.
Court is now session on for Judge Robinson of Circuit Court. Now presiding, ladies and gentlemen, as always, there'll be no talking while her honor is on the bench. You may be seated.
Good morning, everyone. I was ready to call the case of Commonwealth versus Parker.
We are.
And to the media personnel, the buttons that we have to press to turn on the audio are all in place. Okay, thank you. All right, so we're calling the case of Commonwealth versus Parker.
Oh, girl. Did she forget to wipe off her Wonder Skin lip stain? It's purple. Her lips are purple. Maybe this is her lipstick choice for the day. But those of you who use Wonder Skin like I do, it goes on purple and then you wipe it off and then the stain stays on all day. This is my volume. This is the court volume. I might have to boost it up to like 10 again, but then it distorts and then people complain about that. So let me know if you can hear her for now. We'll see if it modulates itself or if I have to do all the work. Her collar is amazing. Look at her collar underneath her judicial robe today. At least she wears a robe. All right. That's her collar. Here we go.
Okay, thank you. All right, so we're calling the case of Commonwealth versus Parker. For the record, let it reflect the Commonwealth attorney is present, Mr. Jenkins, with Ms. May. Good morning to you both.
Good morning.
The defense is present, Mr. Rogers and Mr. T. Good morning to you both.
Good morning.
The defendant is present, Ms. Parker. Good morning to you both. We rested yesterday. Is there anything you need to address this morning?
Yes, Your Honor, I have two matters.
Okay, yes, sir.
The first is that the court yesterday, as I understood it, we agreed to admit the full and unredacted interview between Dr. Parrish and Dr. Parker. I needed time to just place that on a USB drive. I have done that. It's on Madam Clerk's counter there. I understood at the time that the court had admitted it, and I just needed to provide it. But if the court had not admitted it at that time, I am moving to reopen and admit it as Commonwealth 6.
Any objection?
Not any objections to reopening for the purpose of amending that. That's it.
Okay, so friends, Commonwealth is reopened, and we will admit it. Does Madam Clerk have it now?
Yes, it's
Okay.
right there.
All right, and this would be 6, Madam Clerk? Okay, so admitted, and again, this is just the full video of what's already a redacted version in evidence. Okay, and now that that's done, do you rest again, Mr. Jenkins?
Yes, we rest the reopened case, yes.
Okay, and the second matter.
The second matter, Judge, is just as a preliminary matter, I understand that the defense, pursuant to their own subpoenas, intends to call as their witness several witnesses that have already testified, including Ms. Zwerner, Ms. Kovac, Ms. Parrish, Ms. West, perhaps others. And I just want, as a preliminary matter, to point out Jones v. Commonwealth 2023 VA Act, Lexus 294, decided May 16th of 2023, which holds that it is not proper for the defense to do any impeachment when it calls its own witnesses. And so I am asking the court to instruct the defense not to do any impeachment and not to recross on matters that they already had a full opportunity to cross on. But I certainly would not object to them eliciting new evidence in their client's favor from those witnesses. But in terms of recrossing witnesses they've already crossed, that would not be proper. They're here pursuant to the defense subpoena. So I wanted to raise that issue.
Yes, sir, thank you. Response?
Yes, Your Honor. We would be asking, in the event of calling these witnesses, that they be, that we be able to examine them as hostile witnesses.
Okay. And so ultimately, we will cross that bridge when we get to it. You all are entitled to call whatever witnesses you wish, and if they meet the qualifications to be declared hostile or adverse and be treated accordingly by impeaching and or leading questions, then if again they meet that statutory criteria, then that will be allowed. So Mr. Jenkins, I understand your objection now, and it'll be ongoing, and when we get there, we will address it. But again, if they meet the criteria for being a hostile witness, the court will allow them to be treated as such.
I understand. Thank you.
All right, thank you. Okay, so with the Commonwealth resting, defense asked to prepare, time to prepare their motions to strike, and we'll start with them this morning. Are we ready for that?
Yes, Your Honor.
Okay, I'm ready. Please proceed.
Your Honor, the Commonwealth has filed 8 indictments for felony abuse and neglect of children. I am going to just sort of assume that the Commonwealth is proceeding under the fact that there were at least 8 children that were abused and neglected on January 6th. Your Honor, if that's the case, I would say the Commonwealth hasn't established that there were 8 children present in the classroom on that day when this incident occurred. The Commonwealth definitely hasn't established 8 separate incidents. So we have one incident where I guess potentially the Commonwealth believes that there was 8 children present. But the Commonwealth did not present the names of 8 individual children that were in class that day. They presented no roster or role that's confirmed by any employee that was on staff that day. And more importantly, the Commonwealth is required, I'll just read the jury instructions. In this charge of the crime of child abuse and neglect, the Commonwealth must prove the unreasonable doubt due to the following elements of evidence. I know at this point there is a likely study to the defendant was a parent, guardian, or other person responsible for the care of whoever these children are, these unnamed children, and that these unnamed children, this unnamed child or children are or were under the age of 18. There was no testimony that any individual child that was present in the classroom by name was under the age of 18. Also, the Commonwealth has to prove the defendant's willful act or omission in care of whoever these unnamed children are was so gross, wanton, and culpable to show a reckless disregard for human life. The instruction that discusses the definition of willful says, a willful act is one done with a bad purpose or without justifiable excuse or without ground for believing it is lawful. A willful act is intentional or knowing or voluntarily as distinguished from accidental. In terms of bad purpose or without justifiable excuse require knowledge that particular conduct will likely result in injury or illegality. Your Honor, in my own words, the Commonwealth has to establish that Dr. Parker knew, and her response was, so what? I know that there's a weapon and that there's a likelihood that children will be harmed by that weapon or firearm, and I don't care. You know, let whatever happen is going to happen. There was no evidence that was Dr. Parker's response to anything that happened on that day. She was brought limited information, and she responded to the information that she had. Again, I asserted at the very beginning of this, if we look at the behavior of everyone that had contact with JT on that day, they did not believe that there was a firearm. They did not believe that there was a weapon. There was testimony from Zwerner. She was the person that had the most direct contact than anyone on that day. Her behavior did not indicate that she believed that there was a weapon. She left JT in the classroom. She left other children in the classroom. Then we go to this Kovac. And again, she sat with him, had her eyes on him. Watch his behavior. She said it was weird, but her actions in no way indicated that she believed that there was a firearm in possession of JT. And then we consider what Mrs. West testified. She said there were some concerns. She actually observed JT on the playground with the other children. Based on her observations, she was satisfied that there was no weapon. And she only became concerned again when there was a report almost contemporaneously with the shooting that there in fact was a weapon. And then we considered the testimony of Mr. Rawls. He had a lot of contact with JT leading up to this event. On the day of the event, concerns were brought to him. He investigated, put his eyes on JT, was satisfied that JT did not present a danger of harm to the students in the classroom. Your Honor, based on the information that Dr. Parker had, she made decisions. In hindsight, those decisions actually were determined not to be the correct decisions. But that wasn't her decision wasn't an act of neglect. There was no bad purpose, obviously. She didn't intend any harm to the students. Without justifiable excuse, Your Honor, based on the information she had, she took actions that she believed were appropriate based on the circumstances. And so there was no bad purpose. There's really no excuse that we're trying to say other than she did not believe that there was a weapon, so that explains her conduct on that day. So there was no information that she had that she came to the conclusion that was going to lead to harm of her students. And then after coming to that conclusion, she decided that she didn't care. So what? I'm going to leave that threat of harm to those students because of JT having a firearm. The Commonwealth hasn't met its burden to establish a willful act. The Commonwealth has not established the specific names of children and their ages that were present in that classroom. Again, as to consider striking the Commonwealth's case.
Thank you, sir.
For those of you complaining about the volume, and this is boosted on level 10, it's as high as the boost can go. I can hear it fine on my phone. So if you're having trouble, it may be your device. Earbuds can be your friend in challenging audio situations such as like this. There seems to be a mic only on the witness stand, so if it gets to that, maybe it'll get better. Until then, I'm doing the best I can. For those of you who think that you're helping by suggesting other creators who are streaming this stream and you think their audio is better, I will just tell you that I will not stream another creator's stream unless it's mainstream media. I don't do that. They're entitled to get the views. If you would prefer to go watch it over there, you can go do that. But when you do that to a creator who is actively streaming a trial, what you're doing is you're not helping, you're redirecting my viewers somewhere else, and that is not YouTube courtesy. Okay? I can hear it fine, so hopefully you can too. I don't poach other people's streams.
I have just a moment.
Yes, sir, please.
There's a super chat here saying, do you think he would have been better off with the bench, or she would have been better off with the bench trial? You may be right. Let's see what happens here.
Defense counsel's arguments in order. The first was that he did not specify children having been in the classroom, to prove that children were in the classroom. What the Commonwealth is required to prove is actually what is in the indictment. And what's in the indictment is being a person responsible for the care of students under the age of 18 at Richneck Elementary School. So there's no need for us to prove that they were in the classroom necessarily, though certainly victims, we would argue, are in the classroom, but only at the school. That we did not present specific names is not required. The requirement of the statute is that a person responsible for the care of a child under 18, willful act of omission was so gross, wanton, and culpable as to disregard human life. The statute defining what must be included in an indictment does not include a victim's name. And we can think of common examples of indictments that sometimes don't. For instance, did assault and batter another is a very common indictment that does not include any victim's name. So the jury would, the way it is indicted now, be free to find up to the number of victims that they believe existed, in this case with a maximum of 8. And certainly no indictment can be returned twice to the same victim, and that can be explained to them. But at the end of the day, the jury is the fact finder, and they can decide whether, what number of victims there were, if any. And so we think it is inappropriate to try to narrow that to specific names, but rather that the jury can decide based upon the evidence that they have, how many to return or to return none. I'm sorry, how many to find guilty on or to find not guilty on all. Given that the argument generally being we didn't prove there were victims, I think that's definitely false. Children, specific children were referred to, 5 of them by my count, RR, SD, GG, MG, and KS were the specific children that we referred to during the course of the trial.
Ms. Jenkins, if you go with the initials one more time, I have SD, GG, MG,
KS,
KS.
and RR.
Thank you.
That's exactly what I said. They only had the parents of 5 children testify. Somebody said here, Law Kong Express. Why does the state get a chance to respond? They just rested because they have the right to oppose the motion to dismiss. The defense is arguing the state did not prove its case beyond a reasonable doubt. Therefore, you should direct a defense verdict and dismiss the case on behalf of my client. And of course, the state gets a chance to oppose that. And that's what they're doing here.
So we have a total of 5 children that we identified as specificity, but I'll point to the testimony of Ms. Zwerner, who said there were about 20 students in her classroom,
Not enough.
many of whom were in her field of vision at the moment that she was shot. And I would propose that it is up to the jury whether they believe more or fewer victims exist of this crime. And so we believe we should not be required to name specific victims in either the instructions or the indictments. The argument that we did not prove age begins with a reminder of 2 things, and of course the court is aware. The burden of proof at this stage is the light most favorable to the Commonwealth, but I think more importantly that circumstantial evidence is evidence. Had testimony from several parents who said that they dropped their first grader off at school, that their child was in first grade, and that they were in Ms. Zwerner's class. Ms. Zwerner testified that first graders are about 6 years old. And throughout this trial, we've instructed witnesses on the record to refer to people under the age of 18 using initials, and you've had several parents come in and testify using only initials of their own children. The overwhelming evidence then is that these children were under the age of 18. No, we don't have all of their specific ages, but they were first graders in Ms. Zwerner's class, and they were students attending an elementary school. And so I think that the proof of age has been sufficient to survive a motion to strike. There were 2 legal standards mentioned by defense counsel in his argument to the court. And one was that he indicated that we had failed to prove that the defendant knew of the danger. But if you consult the model jury instructions, that is not the standard. The model jury instruction for criminal negligence tells us that to constitute criminal negligence, the Commonwealth must show that the defendant either knew or should have known that the probable result of his or her acts or omissions would be serious injury or death to a child. Given that, the correct standard for the court to apply is not that Dr. Parker knew there was a danger necessarily, but that she should have known of the danger. Having said that, she did know. There were multiple warnings she received from multiple people that there was an armed student. And as I argued during the trial on several objections, whether they thought it was a toy, whether they thought it was a knife, whether they thought just the mere fact that a possible weapon is on campus should have triggered the response defined in the crisis management plan, yet it did not. So it should have known and not known. The second legal standard defense counsel left out is from the willful act definition jury instruction. And so the model on that says a willful act is done with bad purpose. That's what defense counsel pointed out, but it's with bad purpose or without justifiable excuse. And I would argue that that is the part that we rely on here. I do not argue that Dr. Parker had a bad purpose. I will concede that fact. But the law says it's either of those, a bad purpose or without justifiable excuse. And I certainly do believe the evidence has shown that she willfully omitted acts that she should have done, and that she had no justifiable excuse for that willful omission. Given that, Judge, I ask you to deny the motions to strike.
Thank you, sir. This is the defense motion, so they can have the last word, anything additional.
Just want the court to keep in the forefront, again, the actions of everybody. Nobody acted as if there was a actual trial. Not following school policy doesn't result in a criminal allegation. There are acts that should have been done, definitely in hindsight, but based upon information that Dr. Parker had, she did not willfully take any action, or there was no willful omission on her part to put these children in harm. Again, mistakes occurred, but there was definitely no criminal intent. And I would submit that her actions in not criminal. It was just that at the most it was a lapse of judgment. Somebody makes a mistake that should not result in felony allegations or definitely felony convictions. So omitting a step in a school policy should not be considered to be a crime. She acted on the information that she had. She took the steps that she thought were necessary. She did not believe that there was a gun. Nobody that was there acted as if they believed that there was a gun. And, I'd ask that you find that Commonwealth, even at this stage, and like most people in Commonwealth, has not established a willful act or omission. Definitely the Commonwealth is conceding that there has been no specific proof of the age of any child that was in that classroom.
It's really interesting that he made the same arguments that I did, that the Commonwealth has not proven and established or have established a willful act or omission, that it doesn't rise to the level of a criminal act. Was she negligent? Sure. Is it criminal? No. See what the judge does with this.
Anything further before the court makes a ruling on the motion to strike?
No, Your Honor.
I will be honest, we could have done that yesterday. I expected more substantial motion with case law and additional principles of law that the court would probably need to recess and consider, but we are where we are. Having considered this case for 4 days and listened to the motions of counsel and the division of labor in a criminal jury trial. So in that division of labor, in those legal proceedings, questions of facts go to the jury, questions of law go to the judge. A question of fact asks what happened, and it requires evaluating evidence such as the witness testimony and or physical proof. Questions of law ask how does the law apply to those facts, and requires interpretation of statutes, precedents, and constitutional rules. And that's kind of legalese, but breaking it down. The judge decides the question of law, which is what law applies, procedure, and runs the courtroom. In this case, a criminal jury, the jury would decide the facts, which is what happened. To give an analogy, because this case doesn't put itself well to analogy. Somebody is given a ticket for speeding 70 and a 65, but they're stopped in the parking lot. The jury decides the question of fact. Was that driver actually going 70? The judge will decide, does the speeding law apply in the parking lot? So that's the way to wrap your mind around the difference between question of law and fact, which can get quite convoluted. With the question of facts being resolved by the trier of fact, which in this case is the jury, and their job would be to weigh the strength of the evidence and the credibility of the witness. And judges resolve the questions of law. And what would be put to the jury in this case was whether or not Ebony Parker is guilty. And that would be the question of fact. I do say all this because the distinction between law and fact can become convoluted, and they can be mixed. It can be a mixed question of law and fact. The Supreme Court itself has acknowledged that it can be an imperfect science of where is that dividing line, but identifying that line is important, critically important, whether or not it's a question of law or fact. Question of fact goes to the jury, they make the decisions. Question of law, it stays with the judge. And I guess for purposes of the parties' understanding, that influences the courtroom decision maker, the appellate review, how evidentiary rules are administered, and the application of precedent, which I would say there is no precedent for what's before the court of an administrator being criminally charged and tried for what has been presented and what happened that day, June.
That's right, because this has never, ever been attempted before by any court in any state. This is a case of first impression. This is the first time ever a school administrator is being charged with crimes such as these after a school shooting, and in this case, by a 6-year-old. I guess they call it a motion to strike. I have motion to dismiss. That's what I wrote on the Chiron. Don't be confused. It's the same damn thing. But again, you're right. She's equating attempted murder to, traffic violations.
2020, of an administrator, the application of precedent.
There is no
which I would
precedent.
say there is no precedent for what's before the court of an administrator being criminally charged and tried for what has been presented and what happened that day, January 6, 2023, at Richneck Elementary School in Newport News. This court is finding that it is presented with a question of law, which requires resolution by the decision maker. The decision maker on questions of law are the judge, and whose decision is that, and my decision is that this is a matter for the court, and the court is of the legal opinion that this is not a crime, not under the common law of Virginia, nor under the code of Virginia. And the court is going to explain its rationale and ruling.
It sounds like she's going to throw the case out. Sounds like she's throwing it out. Tell your friends. I'm taking this back in one sentence. She's like, this is a question of law. This has never, ever, ever happened in the United States of as such America. She's been a judge for less than a year, and the cojones on her. Tiny Jesus is here. Listen to this. I'm going to start it from the top of this. This is a question of law. I just thought she was going to say it's a question of fact. Hold on, everyone. Wake up.
A crime, not under before the court, is that, and my decision, and whose decision is that, and my resolution by the decision maker. The decision maker on questions of law are the judge, and whose decision is that, and my decision is that this is a matter for the court, and the court is of the legal opinion that this is not a crime, not under the common law of Virginia, nor under the code of Virginia. And the court is going to explain its rationale and ruling. With that being said, if it's not a crime under the common law, nor under the code of Virginia, should the legislature wish to make it a crime, then they will create specific statutory language to do so. When reviewing the statutory language, the court is bound by the plain meaning of that language and must give effect to the legislature's intention as expressed by the language used. And
the defendant is sobbing. You can see her attorney's hand on her back. If you're not watching, I'm narrating for you like a golf commentator. Today, I might sound more like hockey. She is sobbing. Her head is down. She knows what's about to happen. And her attorney has his hand on her back, like, praise be. Here we go. Taking it back one sentence. If the legislature wants to make this a crime, they're going to need to change this, but not in my courtroom, not on my watch. Wow, the cojones on her. Unbelievable. If you can come to your screen and watch the defendant from her back, because that's all we've gotten of her this entire time.
By the plain meaning of that language and must give effect to the legislature's intention as expressed by the language used, and unless a literal interpretation of the language will result in manifest absurdity. So now I look at the statute. Virginia Code 18.2, 371.1. What the indictment charges here is under paragraph B of that statute. It reads, any parent, guardian, or other person responsible for the care of a child under the age of 18 whose willful act or omission in the care of such child was so gross, wanton, and culpable as to show reckless disregard for human life is guilty of a Class 6 felony. The indictments in this case don't address specific individuals, but they list students. The court finds that what has been presented to it is a mashup of legal theory. And it is not clear, based upon the plain meaning of the statute, that these facts are crimes. In the court's analysis, the court is asking, is the crime that Ebony Parker didn't follow Newport municipal policy and procedure, of which was put into evidence, which would have required two people to search the person of JT, either two administrators or one administrator and one security officer, of which the security officer was on site at a different school performing their duties, and the principal, the other administrator present, that's known in this proceeding, was in scheduled meetings during testing. Is the crime that Dr. Parker didn't direct a search of the child's person after being informed that the book bag was clear? Are the 8 counts of the indictment based upon the number of children in the room when the firearm went off? Are the 8 counts of the indictment based upon unfired bullets remaining in the firearm, which would be contrary to established case law as they have to be discharged? Is the delayed reunification the reckless disregard for human life? Is it the emotional trauma of the exposed child who was in the classroom? I believe initials were KS. Is that the reckless disregard for human life? Is it the fearfulness, bedwetting, and hypervigilance of all the children in the school that day that comprises the reckless disregard for human life? Is it because JT wasn't expelled prior to January 6, 2023 due to his previous behaviors, which presumably would be in the province of the prior principals, Dr. Goodman and then Ms. Foster? Or is the crime the lack of heightened response from Ebony Parker due to her awareness of prior issues with JT? The court is unclear. And as previously stated, those legal theories do not fit the plain meaning of the statute. If they are to amount to a crime, then the legislature will need to codify it. Therefore, I do grant defense motion to strike in whole on all counts, all 8 counts of felony child abuse and endangerment under indictment CR, indictment number 24999-541-01-08.
Wow.
So those matters are dismissed. I want to add, my ruling today is based upon legal principles only. Now, it is inappropriate for me to give my personal thoughts or express sympathy or concern, but it's understanding what happened that day was awful, that is agreed upon by all. The criminal matter before me does not call for me to discuss the Newport News school system or make political observations, and I will not comment on optics or engage in speculation. for the media who has contacted this court constantly over the past 2 weeks. There will be no further comment from this court, except to commend the attorneys on both sides, Mr. Jenkins, Mr. Rogers, and Mr. T, for zealously advocating their respective positions and treating this forum with the utmost decorum. It is 9:46, and I did not have the jurors reporting until 10. So I'll ask the parties how they wish for me to discharge the jurors, if they want me to just tell them when they report to the room, or have them brought out and do it on the record. But in discharging them, I will remind them that no one from this court will contact them and direct them about this case. And I will ask the attorneys to please inform all of the witnesses that were to remain constructively sequestered that they are released.
I am stunned. I am stunned. We never, ever, ever see this. We never see a case dismissed after the close of the state's case. I am shooketh. I am very emotional about this because this judge has not been on the bench for very long. And for her to come out and have the stones to throw this case out, this case of first impression in the United States, I personally did not think that she was going to have the cojones to do this. And she did it. And she's like, and that's it. And I have no further comment. This is not a crime. If the legislature wants to make this a crime, then they need to change the law. This is not a crime. The Commonwealth did not prove its case, and all the charges are dismissed. Wow. Just wow. Thanks for watching this with me. She is already appealing the civil judgment, but civil standard is much lower. Negligence is not a crime. Negligence is not criminal. Hold on. Let's hear what she continues to say, because this happened 45 minutes ago, but because the media is on a half an hour delay, I didn't look at the news, so I didn't see this breaking, but it's already broken. Hold on, let's keep going.
So from the attorneys, how would you like me to inform the jurors who are still coming in the building that they're discharged from their duties for this case?
Your Honor, I feel like we should discharge them on the record, but I would have no objection at all if the defendant or other parties wanted to leave and just do that with counsel.
Just counsel only.
That would be fine.
Okay, defense position.
Your Honor, I'm actually okay with the Commonwealth's position.
Okay. So I will step off the bench. So we'll be in recess, and then we'll discharge the jurors on the record once they all report. And to parties, please be quiet. And however you feel about the court's ruling, you can express that outside of the courtroom. This is still a professional legal forum. All right. Thank you very much. And Sheriff, come get me when they've all reported. Thank you.
Please rise.
Thank you.
Court stands in recess.
Dr. Parker didn't know if she was going home today or if she was going into the clink for up to 40 years, or if they were even going to put on a case. This never happens. Let's watch her reaction and her hugs to her family and her attorneys, and revel in the moment.
Court stands in recess.
Justice is still alive and well, at least in Virginia. Thanks, Dawn of Aquarius. Tiny Jesus works, I'm telling you. Here's Tiny Jesus. And she's very emotional. Well, she left the room, but her family seems to be very emotional, all hugging her attorneys and each other. And it's a good day for justice. It's a good day for justice. This was a stretch. Let's FF it a little bit until the judge dismisses the jury. And I guess they cut their cameras at Law and Crime because They don't want to watch the aftermath when that seems like it's going to be the best part. Hang on a second. Let's watch the news piece on 13
Bus operator.
News Now, but I don't want to hear their
With
ads.
every
Hold
shift,
on.
you keep the read.
I will suffer through the ad for you because 13 News Now is on top of it. They've been live streaming this trial too, but it wasn't on their channel today, and I was kind of wondering why. Here we go. Looks like we're going to get to hear the attorneys after court, so hang on for one moment.
And he prepared diligently, and I'm proud of him.
All right. Rewind this.
And I'm happy for Dr. Parker.
Judge
Thank
Robinson
you.
said she had no precedent to work with. Is this a landmark case and a landmark ruling?
I believe it will be, yes.
Yeah.
Thank you all.
Thanks.
Thank you.
Okay, brief but impactful out there. A landmark case and a landmark ruling from one of the lawyers assisting in the defense. Let's go back into the courtroom now. What we're listening to in this courtroom is a 30-minute delay of what we have had our reporters analyzing and breaking down and updating.
Hold on, I'm going to go back to their YouTube channel because I can rewind it, and I cannot rewind it on their live feed. So hold 1 second, please, while I do that. All right, and let's go back to their YouTube so we can rewind and have maybe better audio. Here we go.
And the judge answers the question.
Let me know that you can hear this, okay?
The jury is the trier of fact, and the judge answers the questions of law. And in this case, directly, there was too many questions surrounding the indictment and what the actual indecent liberties that happened to the children, or what that reckless disregard for life truly was. So Judge Robinson did lay out a couple of the questions that she had. Again, those 8 counts were for reckless disregard or wanton abandon for child neglect in disregard for human life. And the judge basically said that she was unclear about what that disregard for life was. Was that the fact that the student wasn't expelled after the first incident that was recorded? Was it the fact that there were 8 still bullets in the gun? Was it the fact that there was emotional trauma for the children that were inside the room? Was it that there was a lack of response from leaders here? So the judge said, since there were so many questions surrounding the indictments itself and what was actually that disregard for life, she said that this case had to be stricken due to logistics when it comes to the law. Now, again, the judge did also say that this indictment didn't express exact people, but what it did do was kind of present a mashup of legal theories. So again, over the last couple days, you remember that there have been conversations back in court about hearsay, what has been striked from the record. And it was very contentious inside court with the conversations that were happening during testimony, because again, there were so many kind of blurred lines at which could actually be said in the court at this time. And the judge reflecting that sentiment in her statements today to us. But again, ultimately, this case that we've been following now for 3 years for Ebony Parker, I could only imagine that this is a weight lifted off of her shoulder. Our crews just spoke with her minutes ago. She didn't want to go on camera, but she did say that she is just so grateful and thankful right now for the judge's decisions. Now, as it comes to the other cases we did hear today, the defense's excuse there in order to strike all these counts was the fact that these kids weren't directly named and that there weren't direct instances to make that wanton or disregard for life true. So again, breaking news, it just came out of the courtroom just moments ago, less than 20 minutes ago, the judge made this decision. Right now, the court is in recess because the jury was supposed to show up at 10 this morning for their assignment. The judge has now decided that the court will go into recess until all the jurors have arrived today. And then Ebony Parker has been excused, but the attorneys will now stay behind and the jury will be formally told about this decision under oath and on the record, and then they will be dismissed by the judge. So again, we thought that today the case might wrap up. We didn't know that this was going to be the end result of what happened today, but this decision definitely came down a little bit quicker than maybe some were thinking. But Connor, back to you.
Yeah, it certainly did, Madison. Going into day 4, every indication was that things would proceed as they have for the last couple days. You were supposed to do a 10 a.m. live hit just to give us a brief update on where things were headed. And instead, you come to us with this massive piece of breaking news. The judge has struck all 8 counts that were alleged against Ebony Parker. Now, I want to get a sense from you now, and you did mention our other crew. Brianna Fallon is standing by. She was there when Ebony Parker exited the courtroom. We will speak to Brianna live on air here in just a moment, but I want to keep Madison with us here first. Madison, can you give us a sense, once again, of how the courtroom reacted to this news? There have been moments during this trial where it has been crowded. I know it was early today. Anything you can tell us about the reaction to such a shocking revelation from the judge?
Honestly, Connor, when the defense made their motion this morning and then the prosecution laid out their arguments against it, and then we heard the defense's rebuttal, it truly seemed like it was up in the air on what Judge Robinson was going to decide. But the moment that she opened her mouth and started laying out some of the reasoning before she actually announced her decision, you could hear a pin drop inside of the courtroom.
Right, and it was empty. And also, she did say something like, I thought this would be a much more, I'm using my word now, a much more full-throated motion with case law and stuff. You could have done this yesterday kind of thing. I feel like she already had her mind made up. Wow. Dr. Parker's been dealing with this for 3 years. Fun fact, in Virginia, judges are elected by members of the General Assembly, i.e. appointed. Thank you. Thanks, Cindy.
The second that the judge was alluding to the fact that she might be throwing out these charges was the second that we instantly saw that emotion come from Ebony Parker, and the room kind of shifted itself into this state of silence, on this state of waiting on the edge of your seat to kind of hear exactly where the judge was going to go with her statement. But the sentiments in which she was saying were pointing to the fact that she was going to point to legalities in the case that would potentially throw the case out. And again, once that decision was made, it felt like a sigh of relief in the courtroom for at least Ebony Parker and the people who have been in the courtroom this last week in order to support her. We did see some of those people that were in the stands watching, supporting Ebony Parker. They did throw their arms around each other in that moment. They did turn to each other and cry in each other's shoulders. Again, this has been a case that's been following around Ebony Parker and her family and her camp for the last 3 years. So I'm sure the emotions that they're experiencing are extremely heightened, and every single person in the room was just waiting on the edge of their seat for the judge to make that decision. But again, she had uttered the words, there is no precedent for this case. We've said time and time again how this case was going to be historic, and those words came directly from the judge today.
Yeah, and this is an event and a case that has in many ways lacked precedent, and that continues on through the trial. Now, my next question may be based around some recency bias here, but it seems as though confusion and questions have really been a standout theme of this trial from the very beginning. There have been questions from jurors, questions from the judge, questions from lawyers about the jurors' state of mind. It really feels like there has been an air of confusion throughout. Is that a fair assessment? Is that something that you saw, and anything to add to that?
Yeah, and that was ultimately why Judge Robinson made the decision that she did make today. That was because she said there were too many questions of legal matters inside the indictment and with what was being presented by both cases, that it was just providing so much chaos for the jury that they were kind of left in a spot where they weren't really able to discern what was just exact fact versus what it was that they were truly trying to describe as that wanton or disregard for life. I keep mentioning that statement, but we do know that the prosecution's job was to prove beyond a doubt that the disregard for life was there. And as the judge had mentioned, there was just so many questions about what that exact disregard for life was that she wasn't going to put it in the jury's hands in order to make that decision. Again, the jury is just the trier of fact. So they're only able to assess the evidence and the information that is given to them by the prosecution and the defense. They're not the ones that are supposed to be hashing out what it means as to the exact statute at which they're supposed to be trying to defend. That is up to the backpacking of the judge, and that is why she made this decision today. She said that given the confusion that the jurors have already had in the past, that confusion was most likely to persist through the day today, and so she made that executive decision. I'm the one that's supposed to be the expert on the law here. My expert opinion on the law is that this just isn't clear enough.
Yeah, she said, legislature, if you want to change the law, you need to change the law, but I cannot convict Dr. Parker on any criminal charges because it doesn't rise to the level of criminal culpability. I see a lot of questions in the chat about, can the Commonwealth retry her? No, they can't. They can't appeal it. They can't appeal it, and they can't retry her because that's double jeopardy. She's been acquitted. There can be no appeal in this case. She's done. That's it. I saw some other people saying, I just tuned in and I was spoiled by the title. Oh, well, too bad, so sad. It's breaking news. It's breaking news. When there's breaking news, I've got to let people know there's breaking news because now there's double the amount of people we had in here in the beginning. The case against Dr. Ebony Parker has been dismissed. She will not be retried. It cannot be appealed by the Commonwealth. And this, in my case, in my opinion, had been a case for civil court. The plaintiff, Abby Zwerner, did prevail in civil court with a $10 million judgment against Dr. Zwerner, which is also on appeal. But this is something that we absolutely did not expect to see when we tuned in this morning. Hold on, I got something happening here on another tab. Hold on one second. Let's keep going with, they're out there doing the work here. This is breaking news on Channel 13. Out of, I think, Norfolk, Virginia.
Another aspect that I want to ask you about that you mentioned in your initial report here is, and something we saw quite a bit yesterday and even the day before, but I felt like especially yesterday, was the emotional trauma for the other children inside the classroom and inside the school. What role did that play in the trial up to this point and then ultimately this decision?
I'm going to put the pause on this right now. And we're going to go to live in court where the judge is just now discharging the jury. Oh man, I can't boost this because it's on their website. I'm going to have to find it on YouTube and boost it after. So forget this for now. We'll catch it on the replay.
Yeah, thinking about the testimony that was given yesterday by those parents, you can see that there are going to be lasting impacts to these children for, if not the rest of their life, for at least the future that they're experiencing right now. It's been 3 years, and we heard that many of those children are still in therapy or counseling today. What the defense was arguing was that there wasn't an exact list of 8 children. You remember, there are 8 counts. The defense said that the 8 counts weren't specific enough when it came to naming exact children, when it came to naming exact ages of children. And then the prosecution had argued, well, we want to remind you, first things first, the 8 counts were for the 8 bullets that were inside of the gun, not 8 students that were mentioned. But in the opening statements from prosecution, they did mention the 20 kids that were inside of Abby Zwerner's classroom that day, that 20, including the 6-year-old child, JT. And since their case was based on the fact that the disregard for life was the trauma that these kids were going to experience, again, what's said in opening statements can't be viewed as to the jury as fact. So it was the prosecution's job to prove that in evidence. That's why they brought the parents of those students to come speak with the jurors and speak and give testimony. And again, the judge said that in answering, even though we did hear some of those traumas, the exact pinpoint of where that exact disregard for life just wasn't pinpointed enough for that trauma to truly be the emphasis in which the basis of those 8 counts stood on.
Okay, and last question for you, Madison, before we get to Brianna Fallon here is, you know, I know we're right in the middle of this. This just happened. We have a tendency to look forward before we fully reckoned with the moment as it stands. But we do want to ask, what's next? Do we know what's next? What does the future hold when it comes to this case?
Yeah, so up next, again, like I told you, court's in recess right now until the jury can formally come back in and be dismissed by the judge. But moving forward, what we have learned across yesterday and also a little bit of today was that there are civil cases that are now pending by those parents of the children who were inside of Abby Zwerner's classroom. I'm sure that legality will now start to move forward, and we might start to see some movement in the case. But again, during those testimonies from those parents, they said that they didn't really want to divulge much information into those civil cases. But the defense did question of whether or not they had something to gain from a possible prosecution in this, from a possible conviction in this case, pardon me, and that all of which the parents said, no, we don't have a direct positive gain from a conviction in this case. We just want justice for our children.
Okay, Madison Schlegel, incredible work all week long. That carries on into today. I'm sure that we will see you plenty today. But for now, thanks so much for this update. We'll talk to you again soon, and great work out there.
Let's take a look at the actual statute, which I have pulled up here. This is the statute under the Code of Virginia. 18.2, 371.1B is what Dr. Parker was charged under. Abuse and neglect of children, penalties, abandoned infant. She was charged under Section B1. Any parent, guardian, or other person responsible for the care of a child under the age of 18 whose willful act or omission in the care of such child was so gross, wanton, and culpable as to show a reckless disregard for human life is guilty of a Class 6 felony. And the judge said, Judge Rebecca Robinson, it did not rise to the level of a crime. It did not rise to the level of a crime. And she dismissed all the charges. Let's go back to 13 and see if we can get to I don't know if this is a replay. Hold on one second. That was a replay of the argument in court, which is way too low. Way too low.
Richneck Elementary School in Newport News. This court.
I'll boost this. We'll go back and watch the dismissal again. It's called a motion to strike in Virginia. Let me know if you can hear this. The audio is horrific on every single channel. So here we go. Back to the beginning of her speech. This is really bad. I'm going to have to, even if I boost it to 10, I don't think it's going to help. We may have to wait for a replay. No, I can't even hear it at all. Hang on.
And what would be put to the jury contention.
Okay, we are back here on Live Impact News in the studio, and you can see on your screen as the judge was reading her decision, Ebony Parker reacting there in the courtroom. You saw her sort of put her head down onto the table in front of her as the judge is, again, eliciting that decision to strike all 8 counts charged to Ebony Parker in this case. And again, one of the very first things that Madison Schlegel told us this morning, that phrase, no precedent for this. You heard it there from the judge in that very specific moment as we got to hear sort of a real-time accounting of what we were updated on by our reporters, Judge Rebecca Robinson making that decision there in the courtroom and the court reacting. Now, we are going to bring Madison Schlegel back onto the program here with more updates for us as news continues to roll in, really reaction continues to roll in to this seismic decision that we've seen this morning.
Seismic.
Hello again, Madison, what updates do you have for us?
Yeah, Connor, obviously you just heard those words there from Judge Rebecca Robinson about the decision that she made in this case. You had mentioned Ebony Parker's reaction and how she was when that decision was made. But ultimately today, we're also hearing from the attorneys of Abby Zwerner. Not even 15 minutes ago, I have received a statement from her attorneys on Abby Zwerner's behalf. I'm going to read you a little bit of this statement here. So mind you, these next words that I'm going to say here for a little bit are coming from the mouths of the attorneys of Abby Zwerner. So their statement reads as follows. One of the many obstacles the city of Newport News placed in Abby Zwerner's path to justice was their argument that they could deny insurance coverage in our civil case because of possible criminal conduct. Today, that's no longer an excuse that the city can hide behind. This was always the Commonwealth's criminal case, not Abby's civil case. Abby complied with the subpoena requiring her testimony once again, despite the emotional toll of repeatedly reliving this tragedy. From the beginning, our focus has remained on obtaining justice in the civil court for the preventable failures that led to Abby being shot. A Newport News jury has already spoken, returning a $10 million verdict in Abby's favor that was in the civil case, remind you. The statement goes on, yet even today, the city of Newport News continues to resist accepting responsibility and delivering the justice that verdict represents. So again, those are words there from Abby Zwerner's attorneys. It kind of echoes the same sentiment that we heard after Abby testified on Tuesday. We spoke with her attorney, Diane Toscano, and Diane had told us that, again, this case was just another representation of the failure of support that Abby Zwerner saw on that day on January 6th, and this statement stands by that. Now, I don't feel that we're going to be hearing from Zwerner directly in this case. Obviously, throughout the last 3 years, in majority, in part, she's been speaking through her attorneys. So I have a feeling that this statement right here, those couple paragraphs that they sent us, is going to be the extent of what we hear from Zwerner's camp at this time. But again, those reactions are still rolling in. At the moment, we do have the 13 News Now legal analyst Ed Booth, who's on his way right here to Newport News to speak with us live to give us a little bit of an insight into the judge's thought process about this decision. Again, this decision was made on logistics of law, and Ed Booth, our legal analyst, will be here to help us sort through that conjecture to make sure that you at home can understand. Even just minutes ago, while you guys were listening to the judge's decision, I had a community member come up to me and say, hey, I've been following this case for years. I just heard the judge threw it out. Does that mean that Ebony Parker is innocent? And I said, no, what the judge ruled today was that the indictments that were brought forward by the prosecution were not outlined specifically enough, and it raised enough conjecture that it would raise confusion with the jury, and the judge did not want the jury to be making decisions on law. That was her job. And so the reason this case was thrown out was because of the multiple legal theories that this case was trying to use in order to prove that disregard for life. And she said it didn't reach that minimum. So again, people in the community here in Newport News are curious about this decision, wondering what that actually means and how it's going to move forward. But again, one of that star witnesses in this case, Abby Zwerner, who we learned today that the defense was possibly going to call back for questioning, has now made a statement on this issue. And again, her attorneys are highlighting what they say is a failure by the city of Newport News in order to claim responsibility about what happened to her on January 6th of 2023.
Right. And Team Brittany says now it gives the city and their insurance company the green light to pay. Also understand that many municipalities are self-insured or they have a self-insured retention. I know we have a lot of insurance brokers in the chat, and I will tell you from my over 3 decades in civil litigation that most municipalities are self-insured or they have a self-insured retention up to $1 million or maybe more. And so the first couple million may come out of the pocket of the city, and then the insurance will kick in. And so that remains to be seen. That is, in a sense, good news for Abby Zwerner in that she may be able to collect her $10 million judgment from the city. But let's take a look at some more breaking news on another local station, which is where I really like to go for the local news because they have a vested interest in these cases. And so let's go to W.
With breaking news. Just after 10 o'clock this morning, I'm
TKR.
Blaine Stewart with that breaking story developing in Newport.
Oh, and now we're seeing the gallery. Well, this is not from today, though. That looks like it was from the civil case. That was not the outfit that she had on today. All right, let's hear what they've got to say.
With breaking news.
Just after 10 o'clock this morning, I'm Blaine Stewart with that breaking story developing in Newport News this morning, where the trial for Ebony Parker, the former assistant principal of Richneck High School, within the past few minutes, that trial has been dismissed by the judge. This is a story that we have been following for years here at News 3. Parker accused of ignoring warnings that led to that 60-year-old student with a loaded gun shooting his teacher, Abby Zwerner. We want to get right to News 3's Brendan Ponton, who's been tracking not only the case for days, but this story for years. And he is live this morning in Newport News with an update on what's going on. Brendan?
Blaine, this was a motion to strike by the defense. They were essentially arguing that the prosecution had not presented sufficient evidence for this to actually be a criminal case. And the judge wound up siding with the defense and granting that motion, and she dismissed all 8 felony charges against Ebony Parker. Now, the judge said in this case that this did not constitute a crime, and that if this were to be a crime, that the General Assembly was going to have to enact laws to specifically say that what Ebony Parker did that day is a crime. But in the judge's opinion today, what the prosecution had laid out, she referred to as, quote, legal theories, and then announced that she would be dismissing the case. And Ebony Parker broke down sobbing in the courtroom. Basically, from the beginning, when the judge started speaking, the judge pretty quickly said, this is not a crime. And Ebony Parker broke down in tears and was sobbing. And then the judge continued explaining her ruling, just saying that these are legal theories and that the prosecution didn't have enough to constitute this as a criminal case. So certainly a very surprising development. A lot of times defense counsels will try to put in a motion like this, and they are very rarely, I would say, granted. So a kind of surprising day here at the Newport News Courthouse. This is day 4 of the trial. We've been here,
Well, it's really day 3 of testimony. First day was jury selection, and I heard that they did broadcast jury selection, which is interesting. We never see that either. Look at Virginia stepping up. I disagree with what that last reporter said, that, she's not innocent. She's innocent. All defendants are innocent until proven guilty, if and when proven guilty. She walked into that courtroom innocent, and she walks out of it not guilty because the judge threw the case out and said she's innocent. This is not a crime. What she was charged with was not a crime. And almost was annoyed that we could have done this yesterday. She could have learned about this last night, that this was not a crime, and that she could have been free last night without having this on her head for one more night, that she was possibly facing a 40-year prison term up to.
every day so far on this case, and the prosecution had rested their case. They called several witnesses, some of the teachers who were at the school that day. But the judge, again, with the big ruling, the surprising ruling, perhaps, that this case is being dismissed. And Ebony Parker actually just left the courthouse. She did not make any comments. So we thought maybe, she would, we asked her if she was relieved or anything like that, if she felt vindicated, and she didn't say anything and just kept walking. So we're waiting to maybe speak with some of the other attorneys in the case and maybe some of the other witnesses. We understand Abby Zwerner, the teacher who was shot, was in the courtroom today because she was expecting to perhaps testify again in the case for the defense side. But now everybody's being sent home, including the jury. The jury actually hadn't reported. This hearing happened outside of the jury, so they had not taken up the case at all at this point. This was
these shots of the gallery from the civil case. The defense asked for the recess until this morning, right? But they didn't come in with case law. They didn't come in with a more robust argument. And so the judge said, you could have done this yesterday. And I think she already knew which way she was leaning. And again, this morning we heard that the defense was going to call, if they put on a case, several of the witnesses who already appeared in the prosecution's case and asked to treat them as hostile witnesses. And the judge said, well, if need be, I'm prepared to rule that way. But I think the judge knew the whole time she was ready to throw this case out. And this did not rise. Ebony Parker's failure to act did not rise to the level of criminal conduct. And if the legislature intends it to be that way, they need to change the law. But as a matter of law today, this is not a crime. All charges dismissed by Judge Rebecca Robinson. Let's keep playing this. And I can't fault the defendant, Dr. Parker, for not wanting to talk to the press today. I'm sure she needs at least a day to decompress and relax, and maybe tomorrow she will start giving interviews. But as of today, she's probably going to take the day off and maybe sleep. She probably hasn't slept in close to 3 years.
Solely a judge's decision to dismiss the case at the request of the defense. So certainly some big news here in Newport News. A lot of people in the city have been watching this case for years, watching what's been going on with this trial. There's been a live stream of the trial that people maybe have been watching and they could follow along. And now we know that the case is being dismissed. It appears it is over. We'll have to ask the prosecution if there's any kind of recourse they can do. I'm not entirely sure off the top of my head, so we will have to ask them. But
no, they cannot appeal. They cannot appeal. There's this thing called double jeopardy. The Commonwealth cannot appeal. This case is over.
Certainly a big day here, Blaine.
All right, Brendan Ponton live this morning in Newport News. I know you've been tracking this case for years, and now this stunning development within the past few hours this morning. We'll see you for an update on News 3 at noon. Again, if you're just joining us here on News 3, we have breaking news coverage that the trial of Ebony Parker, the former assistant principal of Richneck Elementary in Newport News, within the past less than an hour now, that trial has been dismissed by the judge. The judge dismissed 8 counts of felony child neglect in this case. A lot going on, and our Brendan Ponton, as well as other crews throughout the city, are tracking this. Join us on News 3 at noon. We'll get you a live update and bring you up to speed on what happened this morning in the courtroom and what's going to happen next in all of this. And of course, we send breaking updates first right on your phone with the free News 3 app and on WTKR.com. I'm Blaine Stewart. Thanks for joining us this morning, and we'll turn you back now to our regular programming.
That was some more local news. Let's go to the chat. Tell me how you guys are feeling. Hold on. Oops. A non-programmer says, this judge is bold and correct. Thank you for your 5. Mel Game Changers, can a parent now sue Abby for neglect? They have civil suits pending. I don't know exactly who the defendants are. But I'm not sure who the attorney has sued, but maybe. Julie Jensen, would this now be considered case law in future cases? It is the lowest court. It's not going to be appealed, can't be appealed. And so now this is the law, and it could be cited by other jurisdictions, possibly. Definitely the laws that sits right now in Virginia is that this is not enough to charge an administrator. Thanks for being here for 10 months. And at Ford Dread says that's why she had the purple lipstick on. Jared Walker said, well, this is probably the right decision. Dr. Parker should never hold a position of authority with children again. I think she's left. I think she's left school administration. I don't think she is anymore. Stephanie in Canada says, I've only been able to listen, but so happy with this. Thanks for being here for 29 months. Charlie from Australia says, as an Australian, never ceases to amaze me how matter of fact, the U.S. accepts kids with guns. I don't think that is true. I don't think that anybody is accepting kids with guns at all. I mean, maybe what you're saying is that it happens too much. I'm not sure, but thanks, Charlie. Jill Not Wendy says, Melanie, do you think she would have had a better chance with a bench trial instead of a jury? Well, we just watched the judge throw it out, and this was before the judge threw it out. So in retrospect, yes, because that's what the judge did. The defense didn't even need to put on a case. Melissa says, hi, Melanie, thanks for covering this case. They could have gone to the principal too. Why is she off the hook? That I think, again, was before the judge dismissed the case. And as I said, media was on a 30-minute delay. So actually the story broke that the case had been dismissed before we even got to it in our watch. But luckily, I didn't see it. Thank you so very much. Mrs. Bouquet, thank you for your super sticker from across the pond. Nate Taylor says, off trial topic. My 16-year-old granddaughter just texted me. She hit her personal goal and struck out 200 girls in the season so far. I'm so proud. Congratulations to your granddaughter. Thanks for your 5. Cupcakes for Justice. Thanks for your super chat. Charlie says, as an Australian, we just covered that about the kids with guns. And Kelly said earlier, Kelly McLean said, I've never heard of someone going to prison for not being qualified to do their job in a crisis. In my in my opinion, none of those people were qualified. Well, the judge didn't think so either, and she has dismissed the case. Hang on for 1 second, please. Give me 1 second. I need to go off camera for 1 second. Let me see if I can find this breaking news for you. This is WAVY TV. This is also crappy audio. I may need to boost it in a minute, but just let me know if you can hear it.
I'm Chris Horn, standing live outside the Newport News courthouse with a major unexpected development in the case of Ebony Parker. She was the assistant principal back in January of 2023 when a 6-year-old first grader shot his teacher, Abby Zwerner. She survived, but was shot through the hand and into the chest. Parker was then indicted on 8 counts of felony child abuse and neglect with reckless disregard for life. We were expecting the jury to get the case this morning. It never even got to closing arguments. There's a procedure that is done. It's called a motion to strike by the defense. It happens in every criminal trial. It is rarely granted. Today was an exception. Judge Rebecca Robinson decided that after reading case law, which there was none, she used the word unprecedented. We throw that word around a lot. It was literally true in this case that this was not a crime. Those were the fateful words this morning. When she said that from the bench, Ebony Parker broke down. She began crying. She was comforted, patted on the back by her defense attorneys. Judge Rebecca Robinson called this case a mashup of legal theory. What they were citing, the Commonwealth was citing, policy and procedure was violated. However, in Robinson's estimation, no law was violated. There were 8 counts of felony child abuse and neglect. The judge asked rhetorically, where do these 8 counts attach? Do they attach to specific victims? That was not proven in her estimation. Was it the delayed reunification when parents came to Richneck that day, panicked, knowing that there was an active shooter earlier that afternoon? Was it the later effects on the children, which we described and detailed yesterday through the testimonies of several parents whose kids were there that day? Was it the fact that the child was not expelled prior? We knew that there was disciplinary problems the year before in kindergarten. His kindergarten teacher yesterday detailed from the stand how the child tried to strangle her. He was just 5 years old back then. All of this had no precedent, as Rebecca Robinson said from the bench this morning. It was granted. The motion to strike, granted, very rare. I've been covering trials for several years. This has happened twice in my memory. So here we are. The case has been dismissed. Ebony Parker goes free. Of course, she's been free on bond the whole time. She was indicted shortly after the shooting. And now we're hoping to get reaction from the teacher who was shot, Abby Zwerner. I spoke with her mother in the elevator post-decision today. Julie Zwerner told me that Abby will be coming over. She'll be coming over with one of her attorneys from the civil trial, Diane Toscano. We all know Diane from the civil trial. So we're eagerly awaiting reaction from her and her.
Why does everybody have such bad audio? Is it me? I got to unboost this.
Attorney. Once again, the case against Ebony Parker, former assistant principal at Richneck Elementary School, thrown out based on lack of precedent and the judge deciding this is not a crime.
This is not a crime. Wow. Just wow. Let's see what Court TV has to say about it.
We'll be honest, we could have done that yesterday. I expected
This is the judge's decision. Let me know if you can hear this. This is a video on Court TV. So maybe, just maybe, they boosted their sound. So if you missed it the first time, this is the judge's decision to what they call a motion to strike in Virginia. And that is made after the close of the Commonwealth's case, in which the defense says the Commonwealth did not meet their burden. They did not prove beyond a reasonable doubt that this was even a crime, didn't rise to the level. And this is the judge's decision. Let me know if I need to boost this, please.
More substantial motion with case law and additional principles of law that the court would probably need to recess and consider. But we are where we are. Having considered this case for 4 days and listened to the motions of counsel and the division of labor in a criminal jury trial. So in that division of labor, in those legal proceedings, questions of facts go to the jury, questions of law go to the judge. A question of fact asks what happened, and it requires evaluating evidence such as the witness testimony and or physical proof. Questions of law ask how does the law apply to those facts, and requires interpretation of statutes, precedents, and constitutional rules. And that's kind of legalese, but breaking it down. The judge decides the question of law, which is what law applies, procedure, and runs the courtroom. In this case, a criminal jury, the jury will decide the facts, which is what happened. To give an analogy, because this case doesn't put so well to analogy. Somebody is given a ticket for speeding 70 and a 65, but they're stopped in the parking lot. The jury decides the question of fact. Was that driver actually going 70? The judge will decide, does the speeding law apply in the parking lot? So that's the way to wrap your mind around the difference between question of law and fact, which can get quite convoluted. With the question of facts being resolved by the trier of fact, which in this case is the jury, and their job would be to weigh the strength of the evidence and the credibility of the witness, and judges resolve the questions of law. And what would be put to the jury in this case was whether or not Ebony Parker is guilty. And that would be the question of fact. I do all this to say on this because the distinction between law and fact can become convoluted, and they can be mixed. It can be a mixed question of law and fact. The Supreme Court itself has acknowledged that it can be an imperfect science of where is that dividing line.
The jury is the finder of fact. The judge has to rule on questions of law. She researched this very well, seems. And she said, it's my decision. This is a question of law. Shannon, thank you so much for your Venmo. Says, thanks for spending the days with us. You make work tolerable. We appreciate you. Love you with all my heart. Betsy, I love your face also. XOXO. Thanks for your Venmo. And Susan, thanks for your very generous Venmo. She just puts a little gift box in there. Thank you, Susan, so very much. I appreciate you. Guys, more than you know, this is a labor of love. This has not been a very highly viewed trial. And so spending hours a day with you is my pleasure. And I appreciate you so much. And for somebody to say she's lucky she had a black judge, I don't do racism here. I don't see color. So this is like your second odd comment in a row. Just dial it back a notch, would you? Here we go.
Identifying that line is important, critically important. Whether or not it's a question of law or fact. Question of fact goes to the jury, they make the decisions. Question of law, it stays with the judge. And I guess for purposes of the parties' understanding, that influences the courtroom decision maker, the appellate review, how evidentiary rules are administered, and the application application of precedent, which I would say there is no precedent for what's before the court.
Right.
Of an administrator.
She said, what I've been saying all along, this is a case of first impression. This is the first time a school administrator has ever been held criminally or has ever been criminally charged in a school shooting case.
Being criminally charged and tried for what has been presented and what happened that day, January 6, 2023, at Richneck Elementary School in Newport News. This court is finding that it is presented with a question of law, which requires resolution by the decision maker. The decision maker on questions of law are the judge, and whose decision is that, and my decision is that this is a matter for the court, and the court is of the legal opinion that this is not a crime, not under the common law of Virginia, nor under the code of Virginia. And the court is going to explain its rationale and ruling. With that being said,
it's not a crime. It's not a crime. If the legislature wants to make it a crime, they need to change the law. But I'm not going to sit here as a judge and convict this woman of something that I don't think is a crime. Yes, the purple lipstick is a choice. Yes. I also thought maybe she used the Wonder Skin lipstick that we all use, the lip stain, and forgot to wipe it off. But her lipstick color doesn't really matter to me. What matters to me is her ruling on the law, and she's right, in my opinion. This woman cannot be tried again for these same charges. That's double jeopardy. And yes, it is dismissed with prejudice. Here we go. This is not a case of a mistrial. In the case of a mistrial, then the state can charge again. They did it to Karen Reed and tried her twice, even though the argument there was also double jeopardy. Didn't work. This is a judge dismissing a case on the law, and this criminal defendant, Dr. Ebony Parker, cannot be tried again for these charges.
if it's not a crime under the common law nor under the code of Virginia, should the legislature wish to make it a crime, then they will create specific statutory language to do so. When reviewing the statutory language, the court is bound by the plain meaning of that language and must give effect to the legislature's intention as expressed by the language used. And unless a literal interpretation of the language will result in manifest absurdity. So now look at the statute. Virginia Code 18.2, 371.1. What the indictment charges here is under paragraph B of that statute. It reads, any parent, guardian, or other person responsible for the care of a child under the age of 18 whose willful act or omission in the care of such child was so gross, wanton, and culpable as to show reckless disregard for human life is guilty of a Class 6 felony. The indictments in this case don't address specific individuals, but they list students. The court finds that what has been presented to it is a mashup of legal theory. And it is not clear, based upon the plain meaning of the statute, that these facts are crimes. In the court's analysis, the court is asking, is the crime that Ebony Parker didn't follow Newport News policy and procedure, of which was put into evidence, which would have required two people to search the person of JT, either two administrators or one administrator and one security officer, of which the security officer was on site at a different school performing their duties, and the principal, the other administrator present, that's known in this proceeding, was in scheduled meetings during testing. Is the crime that Dr. Parker didn't direct the search of the child's person after being informed that the book bag was clear? Are the 8 counts of the indictment based upon the number of children in the room when the firearm went off? Are the 8 counts of the indictment based upon unfired bullets remaining in the firearm which would be contrary to established case law as they have to be discharged? Is the delayed reunification the reckless disregard for human life? Is it the emotional trauma of the exposed child who was in the classroom? I believe the initials were KS. Is that the reckless disregard for human life? Is it the fearfulness, bedwetting, and hypervigilance of all the children in the school that day that comprises the reckless disregard for human life? Is it because JT wasn't expelled prior to January 6, 2023 due to his previous behaviors, which presumably would be in the province of the prior principals, Dr. Goodman and then Ms. Foster? Or is the crime the lack of heightened response from Ebony Parker due to her awareness of prior issues with JT? The court is unclear. And as previously stated, those legal theories do not fit the plain meaning of the statute. If they are to amount to a crime, then the legislature will need to codify it. Therefore, I do bring defense motion to strike in whole on all counts, all 8 counts of felony child abuse and endangerment under indictment CR, indictment number 24999-541-01208. So those matters are dismissed. I want to add, my ruling today is based upon legal principles only. It is inappropriate for me to give my personal thoughts or express sympathy or concern, but it's understanding what happened that day was awful. That is agreed upon by all. The criminal matter before me does not call for me to discuss the Newport News school system or make political observations, and I will not comment on optics or engage in speculation. For the media who has contacted this court constantly over the past 2 weeks, there will be no further comment from this court, except to commend the attorneys on both sides, Mr. Jenkins, Mr. Rogers, and Mr. T, for zealously advocating their respective positions and treating this forum with the utmost decorum. It is 9:46, and I did not have the jurors reporting until 10. So I'll ask the parties how they wish for me to discharge the jurors, if they want me to just tell them when they report to the room or have them brought out and do it on the record. But in discharging them, I will remind them that no one from this court will contact them and direct them about this case. And I'll ask the attorneys to please inform all of the witnesses that were to remain constructively sequestered that they are released. So from the attorneys, how would you like me to inform the jurors who are still coming in the building that they're discharged from the duties for this case?
Your Honor, I feel like we should discharge them on the record, but I would have no objection at all if
So they were going to discharge them on the record, but I don't know that anybody televised that. Hold on. Oh, yes. Here it is. Okay. So they cut. Thank you for cutting out the break and then calling the jury back. No, maybe they're not showing it to us. They're not showing us them discharging the jury. And I just want to make sure the record is clear because all of the research that I have done indicates that Judge Rebecca Taylor was elected to the bench in Newport News in 2025 for a 6-year term. And I'm looking at a Newport News Circuit Court Clerk's Office post from October 3rd of 2025. Please join us in congratulating Honorable Rebecca M. Robinson, Judge of the Newport News Circuit Court. I'm looking at the Senate resolution, January 14th of 2025, which indicates that Rebecca Robinson was inducted as a judge of the 7th Judicial District for a term of 6 years, commencing April 16th of 2025. But then also circuit judges elected. This was posted February of 2025. Rebecca Robinson of Newport News to the 7th Judicial Circuit starting August 1st. But then Terry, you sent me an email that she's been on the bench for about 7 years. So it's unclear, but all of my research says that she was just elected in 2025. So I don't know if she was a judge somewhere else. But just, I want to make sure that the record is as clear as it can be on that. I guess we'll find out more. Although the judge said, I'm not talking to the press, like ever. She's not going to. And so, well, it says she was newly elected. So I don't know. That's the receipts that I have on it as of now. It seems to be unclear. Maybe it's her second term, but I can't find that anywhere. There's not a lot of information on this judge at all. That is it for today for this case. This is mind-blowing. We never, ever, ever get to see this. I thought I'd be here for the whole day with you watching another day of trial, but as it turns out, Judge Rebecca M. Robinson, Newport News, Virginia, has dismissed all charges against Dr. Ebony Parker, and the case is over, and she has been acquitted, and she is now free. I don't know what else I'm going to cover. Probably something else this afternoon. Open to suggestions. What do you guys want to talk about today? What do you guys want to talk about today? She may have been a judge in a different court. That may be true. But from what I can see here, she was elected to the 7th Judicial District for a term of 6 years beginning in 2025. So there's that. You're going to want to make sure that you have all of the notifications set so that you will know. I likely will go live this afternoon on another topic. There are several things in my inbox that I have not had the opportunity to look at yet, which I will. All right. So plan on having lunch, and I think I'll come back this afternoon, barring any other emergencies like the 3 I've already had this morning in my family. Not really emergencies, but fires that need to be put out. Wise Old Owl says this is a huge wake-up call for all to ensure safety for kids. Take all concerns seriously. Testing can wait. Thank you very much for your 10. Kimberly says, new case in Oklahoma. Richard Glossip released on bail 2 days ago after 30 years on death row. Now pending a new trial. That's interesting. Oklahoma does not allow cameras in the courtroom. And so sometimes it's kind of a letdown when we cover all of these cases and then we're never allowed to see the trial. But I will take a look. I sat there and said, not my problem, says Charlie A. from Australia. Thank you very much. And Sunny Days said, so she won't be charged. She was charged. The Commonwealth put on their case, and the case was thrown out by the judge. So she will not be tried again. Her case has been dismissed, and she is, by operation of law, acquitted. And that's all I have for you today, as of right this moment, on the case of Virginia versus Dr. Ebony Parker. Stay cool, stay kind, stay classy. Don't believe everything you read on the internet, and try and, try and keep your bickering to a minimum. I see Brittany was trying to moderate a whole bunch of fights in the chat, and she probably doesn't have patience for that today. I love you guys. I love my moderators. I could never, ever, 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 ever do this without you. I love you guys so much, and I will see you real soon. The Matas are having a fundraiser for Aaron Spencer. It is graduation season. It is end of year season. I have 5 kids. I have a million things going on. If I am able to join it, it's on Saturday, which is hard this time of year. I will try. I don't know what time, but I told them that I would try and I would let them know. I'm sure I can get on there for at least 30 minutes or so. So I'm going to try. That's the best I can say right now in this very, very busy end of year season for parents everywhere in mid-May, end of May. It's May 21st today. I love you guys. I'll see you real soon. Make sure you have your notifications set. Smash the like button on your way out. Hype the video if you can. Do all the things that YouTube likes. You know what they are. I love you. Peace.